right, well, welcome everyone. Thank you for coming today. We are going to focus our today's training on using criminal records for effective case management. I'm so excited to have you all here. My name is Maddie Nation. I work with Homebase. Homebase is a nonprofit technical assistance provider that works with the county to deliver trainings and technical assistance across this community to providers who are focused on serving folks experiencing homelessness, which is quite a mouthful. But basically, we are here to help with some of these complex topics that come up, like how should we be using criminal records to best support our clients. So again, happy to have you all here today. Before we get into the content of today's training, I want to turn it over to our partners at HSA to see if they have any opening words that they would like to give. So Kalia or Leslie, is there anything you'd like to say?
Thanks, Maddie, and thanks everyone for joining in today's training. I know it's always busy for you all working with uh, community members, and so appreciate your making time for this training. And we're excited to partner with Homebase to bring you this training because we know criminal backgrounds can serve as barriers for a lot of clients, both in terms of access to housing and jobs. And so this is an important component of the work that you all do.
Great. Thank you so much. So without further ado, I'm going to turn it over to my colleagues, Esther and Shivani, who are going to walk us through today's training. Thank you.
Sorry, I couldn't unmute myself. Um, Thanks so much for having us, and we are excited to get into this topic with you all today. And so we're going to really kind of just dive right in and talk about a lot of the different complexities around criminal records, clearance, expungement, and what kind of all of that means for us in kind of working with clients with records. And so, for a quick introduction, I'm Shivani. I am a senior policy analyst at Homebase, and I'll pass it to my colleague Esther.
Hi, everyone. Happy to be here. My name is Esther Welch, and I'm a directing attorney at Homebase.
And Homebase is we're a nonprofit that's been working with communities around the country for almost 30 years to kind of build community capacity to end homelessness and to reduce poverty. And so I know that you all work with us really closely, but you might not have worked with our criminal legal system initiative as much. That's a newer initiative within Homebase where we're really working on the intersection between homelessness and the criminal legal system. And what we're really trying to do is improve housing outcomes for folks with records. We're trying to decrease kind of law enforcement and court involvement for people who are experiencing homelessness and generally trying to reduce the strain on public resources across all these systems. And so today we're going to provide a little bit of introduction, context for thinking about records in this moment in our history. Then we're going to talk about automatic record clearing and some and what that can look like, as well as what happens when automatic record clearing doesn't kick in. And preview, California has very extensive automatic record clearing, which is exciting, but there's also a lot of caveats. We're really going to get into it there. Then we're going to talk about, what are some of the barriers and obstacles to getting your record cleared, and then ways to use kind of criminal records to advocate for clients, and then end with a discussion and time for questions. And apologies, it's not super easy for me to see anything in the chat, so feel free to just come off mute and say anything or ask any questions at any time.
Yeah, Shivani, I'll let you know if there's any questions for you in the chat.
Okay, great. I think everybody knows this stuff, but you can please feel free to mute yourself if you're not talking. You can add captions if you just click on show captions for while we're talking, and feel free to say questions out loud or put them in the chat, and then that should take care of everything. So, we're going to start off with some introduction and context. And we're going to start with talking about some key terms because whenever we talk about the criminal legal system, there's a whole lot of clunky jargon that I know that in our systems we also have a lot of clunky jargon, but it can mean different things in different systems. So, we just wanted to clear up some of those terms that we're going to use throughout the presentation. We're going to do a little quick poll. We're going to talk about just what records can tell us or not tell us, and then a little bit about why records really matter, especially in this context today. So, the words that just gonna go ahead and define are what is a criminal record? What's the difference between a misdemeanor and a felony? What's a conviction? What does supervision mean? What does diversion mean in this context? What's a public defender? And what's a fine or a fee? So real quick, does anybody know kind of what's the difference between a misdemeanor and a felony? You can put it in the chat or just come off mute. Okay, that's okay. No worries. So misdemeanors are typically considered lower severity types of charges, and felonies are considered higher severity. Typically, people in jail are serving sentences. Well, most of them are just being held pre-trial, but those who have been convicted are serving misdemeanor sentences, whereas felony sentences are more likely to be served in federal or state prison. But I want to problematize, thinking about certain charges as lesser or more severe because a lot of times the charge cannot tell us a lot of information about, the person or the context behind their record. So a conviction is a finding of guilt. And a lot of times convictions, we might imagine that it happens through a whole trial and there's a jury and all these kinds of things. But most of the time it's happening through somebody having to plead guilty just to make their case kind of end. Supervision is when people are serving part of their sentence in the community, either on probation or parole. And this can happen, maybe they didn't go into jail or prison at all, so it could be in lieu of incarceration, or it can be added on to incarceration. And the important thing to know with supervision is that there's a lot of rules that you have to follow in order to stay compliant. And if you don't follow those rules, you might get what's called a technical violation, which can send you right back to jail. Diversion. Does anyone know what diversion means in this context? I know we have diversion in the homelessness context. Any thoughts? Again, sorry, I cannot see the chat.
Well, diversion is when the court opts to charge with like some sort of conditions, like completing a program or certain community service.
Yeah, exactly. Yep. And ideally, then you get the arrest and the charge off of your record if you successfully complete the program. And it can happen at different points. So some people are even offered diversion at the point of arrest by police officers and then through kind of the system. So there could be multiple off ramps. But the thing to know about diversion is that these programs are often pretty hard to complete. And sometimes they're not even relevant to the person. But I know in Philadelphia, where I used to work in Philadelphia city government, I still live here. A lot of people had a lot of trouble completing those diversion programs because they had to figure out transportation and childcare, and also they had to pay for the programs, several $100s sometimes. So it's an off ramp. It could be a good thing, but in reality, a lot of times it introduces new barriers, and people don't actually get stuff off their record through diversion. So folks are probably familiar with public defenders who are court-appointed attorneys when folks are not able to afford their own attorney. And then we talk a lot about fines and fees in the context of the criminal legal system. So fine is usually for some kind of punishment, like a speeding ticket. But then a fee, there's all these fees that once you're getting your case processed, you might end up being on the hook for. I know some places will charge you a fee to print out your case, for example, in the courtroom. And those fees can really add up. Any questions on those words? They'll come back, so they'll hopefully be useful. I'll keep going. So today, of course, we're going to be focusing on records. And I wanted to start off with just clarifying that records can't actually tell us a ton. But oftentimes we're using records to make big judgments, like whether people are dangerous to themselves or to others. Records often cannot tell us that. Even if somebody has a violent charge, that's not necessarily an indication of dangerousness. In some states, like various behaviors that we wouldn't even consider violent are given a violent charge, like purse snatching or meth production, stealing drugs, any number of things. In addition, even if people have been convicted for something we would consider a violent action, a lot of times that doesn't predict what their future behavior will be like at all. So records can't really tell us about dangerousness. They may not even tell us about the outcome of somebody's case, depending on the source of the record. Certainly don't tell us whether people deserve resources or whether they're trustworthy. And the research shows that having a record is no prediction of whether somebody's a good tenant or not. What records can tell us is the type of contact that somebody has had with the criminal legal system. And we know that that contact is heavily influenced by all the inequities baked into our society, right? So it's going to be influenced by race, ethnicity, gender, skin color, neighborhood, socioeconomic resources, and any number of other things. So it's telling us a skewed picture and it's influenced by deep inequality, right? That's baked in the system. Um, Records could potentially give us some information to understand the whole person, build rapport when they're disclosed voluntarily. They could kind of give us some idea of what services might help, what trauma-informed approaches could help. For example, a lot of people, who are leaving, especially after a long sentence, are coming out with a lot of custodial trauma, so it could help to know that. And it could also be helpful to know what requirements does this person still have to comply with to stay in the community, so we can find housing that matches those requirements. Okay, so now we're going to take a little poll, little quiz. Don't only answer the first three questions. We're going to come back to question four. So I'll let folks get on that Menti poll. So you can go to menti.com and enter this number, or you can just scan it with your phone. And let me know if it doesn't work. I'm not always the best at Menti polls. But I'm going to stop sharing my screen in a second once everybody gets that. And then I'm going to share. Let me just put the code in the chat. 6255731. Okay. So did it work if you clicked on it? Or does it say I have to start it or something? It worked. Okay. I see people's. Okay. So first question was how many Californians have criminal records? So we'll let some of the votes come in for a second. All right. Right answer is 8 million. So folks 5 million was second second guess. But yes, most people are right with 8 million. And all right, next question. How many Californians are on community supervision? So option between 50 to 100K, 100 to 200, or 200 to 300. This could include probation or parole. And majority of people are right again. It is 259,000 people, which is more than are in jails and prisons. So in San Mateo County, how long is the average probation term? Got less than 6 months, 6 months to a year, 1 to 2 years, 3 to 5. And it is Drum roll, 3 to 5, actually. 3 is average length for misdemeanor cases, and 5 is average length for felony cases. And this is not taking into account parole lengths, which can be much longer. So don't go on to the next question because we're gonna do that one later. Let me stop sharing. Oops, I lost all my windows. Okay, now I'm back. And bring back the slides. Give me 1 second, sorry. Okay, thank you for playing the poll. All right, so why records? Why are we talking about this? I think everybody kind of knows this, but just to reiterate, records really matter because they feed that cyclical relationship that we all see in our work between homelessness and incarceration. So, formerly incarcerated people are almost 10 times more likely to experience homelessness after release than the general population. And then people of color and women experience that rate even higher. They're at even greater risk of homelessness. And then if you've been incarcerated more than once, that likelihood jumps up much higher as well. Then people experiencing homelessness are a lot more likely to be arrested than the general population, which kind of continues that cycle. And then even if folks are in jail for a very short time, like a couple days, 1 day, all of that will still increase the risk of a lot of negative outcomes, including suicide, job loss, rearrest. So even a very brief jail stay is enough to destabilize every aspect of somebody's life, not to mention their housing. And we probably are all kind of aware, but we're in this context right now, nationally, especially in California, of kind of growing criminalization of homelessness, which means that more and more people are unfortunately going to have records or come into contact with law enforcement, which just puts them at risk of losing that probation status which is a very vulnerable status in the community, potentially going back to incarceration. And we'll talk more about how probation affects record clearance in a little bit. So this is just a timeline of a few of the events that have taken place over the last few years that people are probably familiar with. But starting back in 2018, Martin versus Boise was a Ninth Circuit ruling that states that states could not criminalize basically sleeping outside if there weren't any other options. And then, as we all know, last year, Grants Pass versus Johnson basically nullified that ruling and said that actually you can punish unhoused people for sleeping outside, even if there is no other option. Um, After that, we saw that Governor Newsom put out an executive order kind of directing state departments and agencies to adopt encampment clearance policies consistent with Caltrans policy. We saw last November that voters passed a tough on crime measure in California, Prop 36, that's going to swell prison populations again by 35% over the next few years. The pit count from last year was really high. It was a record high across the country as well as in California, where we see, over 24% of the homeless population. And then most recently, we saw that Governor Newsom released a proposed ordinance that he suggested that communities adopt that criminalizes homelessness. And I don't even know if he had to do that because between Grants Pass versus Johnson and this May, 50 cities and 3 counties in California have already passed criminalizing ordinances. So that's the charge context we're working in where records, matter even more. So we wanted to give a little bit of background about something exciting that's happening in California, which is that records are being automatically cleared in some cases. So in general, record clearing means just removing somebody's criminal history, either through an automatic process or by a very arduous process of petitioning a court to do it. California has the most extensive automatic relief process in place right now. So a lot of arrests, misdemeanors, and some felonies are getting cleared. And if they're not cleared automatically, again, you can petition, but that is a painful and difficult process. So to go through kind of 3 buckets of relief, in some cases, you're getting automatic relief, and we'll talk more about that. In other cases, you have to petition, but courts must grant the petition if your petition meets all certain requirements. And then in third cases, or the third category of cases, courts may grant a petition but it's discretionary, like it has to be in the interest of justice or any number of other kind of plausible reasons why court may or may not do it. So, for arrests that did not result in a conviction, that's going to be the easiest and the biggest bucket of automatic clearances. So any misdemeanor arrest that didn't get a conviction since 1973 is eligible a year after the arrest. Felony non-commissions are eligible after a certain waiting period. And I'm not going to go through all these things in a lot of detail because we have a ton to get through, but we are going to send out these slides so you can kind of see the factors that would kind of determine if somebody's eligible or not. And then again, any arrest since 1973 that somebody completed a successful diversion program for is eligible, but as we talked about, it's actually quite hard to successfully complete those. For misdemeanors, people are eligible in certain cases. It's for people who have served their sentence and who aren't on supervision currently anymore or aren't facing new charges. So this gets a little bit more complicated, right? People have to meet more criteria. And again, in the interest of time, I'm going to keep going, but we will send these slides out so you can kind of see the criteria in detail. But some of the ones that I wanted to highlight is if you get your probation revoked, you have to then wait 4 years after the end of the probation period to be eligible for automatic relief. And we know that probation gets revoked quite often, so this is a large waiting period that could be added on. And for felonies, it's the hardest, right? So people are only eligible if the felony is non-serious, non-violent, and doesn't require sex offender registration. That's going to exclude a lot of people. And it's going to kind of privilege white people who are, because of the biases in the system, the most likely to have lighter charges. And then there's a lot of other criteria that kind of influence whether you can actually get your felony automatically relieved. Again, slides will go out, so don't worry too much about the details, just kind of providing a high-level overview. So, cool, good news is that records are being relieved under this new process. So it started in July 2022, and in the first 2 years, the Department of Justice cleared 12 million records. That's not 12 million people, but just records for a smaller subset of people. Most of these were old arrests, a lot of DUIs. If you have more complicated or serious things, you're less likely to get it cleared automatically. An important finding is that Black people are overrepresented in the group that's unlikely to benefit from record relief. So we're already seeing inequities play out in how record relief is being granted because of all those very restrictive criteria, right? So that means Black people are more likely than white people to have to go through a lengthy process to get their record cleared. Then the DOJ, once a record is automatically relieved, they send that list to county courts to update. But there's no actual process in place to make sure that county courts are updating their records. So it's unknown, and county courts records are what drives a lot of kind of like record looking up at the local level. There's also no current way to check easily or be notified if your record's been cleared. And so given all this, even if a record is relieved or eligible for relief, it could still show up in various background checks. So zooming out, we have a lot of potential records that are eligible for automatic relief, but there's all these challenges like we saw, and so a lot of people are not getting that. And if you're not getting that, that means you have to petition courts directly. Again, this all depends on certain criteria that you have to meet. You have to not have any new cases, and you can't be on probation or parole for any case. And this is a hard process to go through. In some cases, a court might be required to grant your clearance. In other cases, they have discretion. There's also some other relief options for survivors and people with convictions related to sex work. And there's some relief options for folks on sex offense registries in some cases. So I know that was breathing through, but I want to make sure we have time for everything else. But feel free to throw questions in the chat, and we'll have time for questions at the end too. And here are some resources to kind of learn more about record clearance and what it looks like in practice. So I'm going to stop talking and turn it over to Esther to talk about some barriers and obstacles to getting that relief.
Thank you, Shabani. I do want to just like pause for a second and see if anybody has any questions about what Shabani just discussed. I feel like she covered a ton very relatively quickly. Was there anything surprising or unexpected? It was all crystal clear. Okay. Well, I'm going to go in, as Shabani said, to talking a little bit about some of the specific barriers and things to record clearing. But I will say, I think we're making pretty good time here. And so if folks have questions, if there's anything that's not clear, please come off mute, raise your hand, go in the chat, stop us. We really, really want this to be uh, clear for everyone. We think it's really important. Matilda, thank you for your comment. She said that it was clear life experiences gave her a little intro into this. Yeah, it is yeah, I think it's something that probably doesn't surprise a lot of people who have had any experience or exposure, but I think some people just hear record clearance, they hear probation, they think these are really great things. And there are, in fact, tons and tons of barriers to them. So, okay, for some reason, my Zoom screen is being funny. So, Shabani, are you still screen sharing?
I think I am. Can anybody else see the slides?
Yes, we can see the slides. Esther,
Okay.
is it one of the tabs at the top? Are you on meeting instead of Shabani's screen?
No, it was even sillier than that. I don't want to explain. It was really, yeah. Thanks, Shivani and Maddie and everyone for bearing with me. I may have just been looking at my own PowerPoint the wrong way and not the screen. Okay. Um, okay, so the first thing we want to talk about is eligibility requirements to get your record cleared. And Shabani touched on this a bit, but it's just going to get into it a little bit more because this is one of the main barriers is just that I think there's a notion that, you know, if you do your time, you do whatever, it's over and done with, your record will get cleared, especially if it's for things that we think of as like de minimis or like more minor, right? But in reality, it can be a pretty high bar. And prior to working at Homebase, I worked as a public defender for a number of years. And I can tell you that people get on probation and they think, okay, I'm on probation, I'm in the clear. And in fact, probation can be a really, really hard thing to complete successfully. And so as to that first point, in order to get your record cleared, either through these new automatic statutes that have been created or by petitioning the court, first and foremost, you need to have successfully completed your probation if you were given probation. And what that means is it means you need to have served any jail sentence that you were given, you need to have served any house arrest that you were given, all of those things. And then you have those 3 to 5 years usually in which you have no new crimes come up, you have no violations for probation come up, you've paid all of your fines and fees, you've taken any classes that you were supposed to take, you've done any community service that you were supposed to do, et cetera, et cetera. And I think when we're thinking about people who are dually impacted by both homelessness and involvement in the criminal legal system, that probation violation thing, especially in light of Grants Pass, is so real. Because if it is illegal for somebody to exist outside, right? Like, and if somebody gets an initial arrest or something for that, or if somebody has an arrest for, I don't know, drugs or anything, and they're on probation, then they can get violated every time that they're outside because, you know, that they're outside and they're stopped by an officer. just for existing while being homeless, right? So that can like extend probation for a very, very long time. Somebody just basically is in this waiting zone, hoping that they don't have a run-in with the wrong person and get violated. Because the other thing I will say is that getting a violation for probation is a much lower barrier to prove than proving that someone has committed a crime in and of itself, right? You also, if you've gotten early release, and you were just released early with no probation or anything like that, that counts, or if you're just not currently on probation. But as I said, this is a big barrier because probation terms are very long and they can just get extended and often do get extended again and again and again. Another thing that's required in order for you to be eligible for any kind of clearance is that you have to have paid all fines, all fees, and reimbursements that are ordered by the court as part of your sentence when you're convicted. And obviously, when we're looking at our shared clients, this is a really big barrier for people who have fewer resources. It can be insurmountably difficult to impossible to pay fines, fees, and reimbursements. One thing I will note is that sometimes courts will order restitution, which is an amount that is ordered to sort of like make up for harm that's been caused. You don't need to pay the restitution amount in order to get record clearance, but any other dollar amount needs to have been paid. You can't have, in addition to not being able to be on probation, you also can't have any new crimes that have come up. You can't be serving a sentence on any offense. You can't be awaiting trial on any offense. Your record at that moment needs to be totally, totally clear. And again, with Grants Pass and with growing criminalization, people who are living outside just have far more interactions with police, and this becomes a greater burden than it was in the past. And then also there are certain offenses that are just ineligible for clearance. A bunch of vehicle code ones where you fail to comply with lawful order and inspection, like you don't pull over when a cop tries to pull you over. And then also sex offenses against a minor are a totally different thing. So next slide, please. So we were talking about probation and how difficult it is to be on probation and not get violated. But we also would love if you could use your camera or go to Menti and enter that code, because we want to explore what some typical San Mateo County probation terms might be so that you can understand all of the things you can get violated for and all the things that you need to do when you are on probation in order to, have successfully completed it such that you could get your record cleared. So
if folks could go on and answer the last question. Did that work? Let's see.
I'm not seeing it on mine, Shabani.
Oh no. Okay, what did I do? Give me a second.
I have a quick question.
Yeah.
Sorry, thank you. So I'm just curious, for probation, do they basically have like a case plan, or how do they come up with the certain expectations that they have and for remaining in compliance? And like, is that something that they develop with the courts? And also, how frequently do they follow up?
Yeah, I mean, I think that's a great question, Stephanie. So conditions of probation, some of them are mandatory. Some of them are things like you can't get a new case and be successfully complete probation. Some of them are not mandatory, they're totally discretionary. So like not using drugs and alcohol should be something that you only get if your underlying crime that you're on probation for somehow involved your being under the influence of substances somehow was implicated, right, in the underlying thing. But judges will order that all the time on things that are not, so the DA can request probation terms. The judge can just order probation terms. And the public defender or the defense attorney often will argue about whether or not a probation term is appropriate at the time of sentencing. Because, if somebody gets a shoplifting charge, why should they be not allowed to drink? Those two have nothing to do with each other. And then in terms of how often you're checking in with your probation officer or what that looks like, sometimes it's as simple as a phone call. Sometimes you don't check in with them at all. And sometimes it's like you're coming in once a week and they're doing site visits to your house. It just really, really depends on what the probation, what the underlying conduct was. Good question, though. Okay, so I think Shabani got this up and working. And go ahead.
Maybe flawed. It might only be, I meant it to be that you could check all that apply. Let me know if that is not right and you had to just check one. But basically what this was asking is which of these are real possible conditions that somebody might have on the probation in San Mateo County. And it looks like I've almost certainly done something wrong on the mentee side, so I apologize. Can you only click one, or is it people who are just not able to see it?
Somebody's saying it was timed out. Is there a way to restart it, Shabani?
Let me try that. Sorry about that. Let me try this again.
Yeah, I didn't respond in time either. I have like a exasperated looking bear telling me I didn't respond.
Oh no, God.
No. I think I am the exasperated looking bear. Oh, answer fast to get points.
Okay, I'm sorry, I can't make it stop timing us. So now you have to just answer if hopefully people can see it, and hopefully you can click more than one.
Yeah, you can definitely only click one. And
Yeah.
also,
Okay,
yeah,
I'll stop with
maybe
this
just,
then.
yeah, maybe just key takeaways.
All right, so okay, people have clicked a few different ones, but basically they are all real conditions. So you can't travel outside of a 15 county radius without permission from your probation officer. You have to be okay with your probation officer visiting you at any time. You can't talk to anyone who might have a felony conviction without permission. That could be your friends or your roommate or your mom. And doing any of those things could result in a violation. Speaking of that, if anything changes in your housing situation, you get a new roommate, you might be moving, your lease is ending. If you don't give the probation officer enough notice, that could be a violation as well. So if we think about all of these rules in the context of somebody experiencing housing insecurity, it becomes almost impossible to imagine how anybody could possibly follow all of them, right? While also just trying to gain stability. So let me turn it back to Esther and sorry about the Mentimeter fail there.
We blame Mentimeter, not you, Shabani.
It didn't understand my vision.
Yeah, it wasn't there with you. Okay. So out the gate, lots and lots of obstacles to even qualifying for record clearance, right? The next barrier we want to talk about is assuming that you are somebody who's completed your probation term successfully, you haven't gotten any violations, you haven't gotten any new cases, you qualify for all of this, but maybe you don't qualify for the automatic probation, sorry, not probation, the automatic record clearance. Then what you need to do is you need to file a petition and petition the court in order to get your record cleared. And this involves a lot of time, a lot of like technical, administrative, legal rigmarole, and a fair amount of money. So here we have just some of the most standard fees and costs that are associated with petitioning to get your record cleared in San Mateo County. And I want to just think, if we're thinking about people who are experiencing housing insecurity, think about the time load that all of these things require, as well as the economic load that they require. So the first thing that you need to do is you need to pay a $60 filing fee for your dismissal application. There are, for the automatic stuff and Penal Code 1203.4 expungements, you don't need to pay the fees, assuming everything goes off without a hitch. But in all other cases, you need to pay those fees. You can apply for a fee waiver. We'll talk about that soon. But it may not be granted. So $60 to even file those things. Then you need to provide a copy of your criminal record or case summary for every single conviction that you have. You have to get those copied from the courthouse, and they will charge you 50 cents per page for those. If you need certified records, which sometimes you do, those are going to be additional money. I think it's like an additional $25 maybe or something. If you need state records through the California Department of Justice, that's $25 for those records. Also keeping in mind that these are you're having to go to the courthouse during the appropriate hours, wait in line, request that they make these copies and that kind of thing, come back sometimes to pick them up during the appropriate time, go to the clerk's office to have everything filed, have it all there, right? Like, it's a huge time suck to do these things. That's why law firms have people that their sole job is to just like go between different court offices filing things, right? Then you're going to get your dismissal packet all together, and you're going to want 5 copies because you need to serve the DA, you need to serve the court, you want a copy for yourself, you want a copy for the public defender's office, and you want another copy that you hang on to while it's all processing, right? So you get a copy back to you once it's done, but you want the clean copy just in case. 5 copies, 50 cents a page on those copies. In the case of felonies, you're going to need to do live scan fingerprinting. That's $50 just to do the live scan fingerprinting. And then there's additional mailing and clerical costs that may add up. All of that to say, lots and lots of time, lots of money, right? To just like try to get what is a basic and fundamental right to get your record cleared. Another thing that you may have noticed and that we talk about on the next slide, please, is that in criminal expungement and sealing cases, public defenders are not guaranteed for relief. So even people who initially qualify for public defenders on their underlying case often are not going to get the assistance of a public defender once they are convicted. And they are trying to seek relief from that conviction. It's just something that they have to do on their own. And usually they just go on their own. As I said, sometimes there are like self-help office hours or self-help forums, or the public defender will hold like little clinics that are first come, first serve. But often what you're doing is you're going to online guides that may or may not be any good and trying to make sense of it, and then going to the clerk's office and trying to negotiate with them and figure out, it is really truly very highly technical often. The online guide for San Mateo is linked here if anybody is curious. But again, there's no public defender. You have no legal advice. It's you doing it on your own and hoping that you do it right. On the next page, as I said, you can apply for a fee waiver or reduction of fees if you are unable to afford the initial $60 payment. However, you need to prove that you're unable to afford it. And there are a couple of ways to do that. You can, if you receive public benefits, then you're automatically granted a fee waiver. And also, if your income comes out below a certain threshold with your expenses, then you can be granted a fee waiver. But in any case, in order to get that, you need to fill out one of these court fee waiver forms. This is page 1 of 2. And in it, you need to give all of your personal information everything about your income, everything about who you're living with, and that kind of thing. And it gets deeply personal. Like these are things I would not, it would take me a very long time to fill this out in a really ethical and honest way, because they want you to list the income that you receive each month. They want you to list the income of anyone else in your household who you might depend on for support, or for whom the household depends on for support. All money and all property in your control. So that includes any cash on your person, any money in any financial accounts, an accurate valuation of any vehicles you own, any real estate you own. And then you're supposed to go through and itemize any valuable personal property that you have and list all of that out. And then they ask you to go through and list out all of your deductions and expenses every month. So, rent and home payment, average food and household supplies, utilities, medical and dental expenses, installment payments. It's a highly invasive process, right? But it's what you need to do if you are unable to afford this $60 fee. So yeah, just something to think about. $60 could be insurmountable for some people. And while there is an alternative that is available, it requires, a lot of opening yourself up to a lot of scrutiny, right? About some pretty personal stuff. The next barrier that we want to talk about is timeline. I think that a lot of times the way that record clearance comes up when I practice, the way that it would come up with clients, is that somebody is applying for a new job and they got through whatever round of interviews and they found out that they're going to do this deeper background check for people who are offered the job. And they're like, oh my gosh, I have that DUI from 5 years ago. I want to get that taken off my record. Or they're applying for housing. There's some precipitating event that happens where they're like, oh, this thing that's really exciting that I'm qualified for, that I really want, is happening. I'm going to go take care of clearing my record now. Unfortunately, as you all probably predicted, even before you read this slide, it is not a quick process, and it is not necessarily a clean process. Even the automatic clearance takes time. And often doesn't kick in when people are most vulnerable, or in a way that is like terribly easy to anticipate, right? Like there is not always a timeline that we can explain to people. If this happened on this day, then your record will be cleared by XYZ day. It's just not that predictable. So in the months and years after people are released, they are the most sort of susceptible to barriers to housing, employment, benefits, access, insurance, and more. It's those early years and the early time when you're released from custody that people are sort of the most vulnerable, right? And these barriers can be both explicit, like in terms of excluding people from with records from things explicitly, like we won't accept you into this program or give you housing if you have any convictions for XYZ in the last 5 years. And they can also be implicit, just in terms of stigma and discrimination. You're thinking of 2 candidates and you find out that one of them was recently released, and that colors your judgment and you decide to go with the other one. And obviously, when people are first released from custody, this is sort of like this experience is what they're wearing. It's their most recent experience, right? People are often released with few resources or connections. People may be released into communities that are not their own community, especially if they're in prison. You can go all over the state and sometimes all over the country. And in the first 2 weeks post-release, the risk of death increases 12-fold. So just, thinking about the fact that automatic clearance, even when you've done everything you need to do, can still take months at a time when people are very, very, very vulnerable. And then on the next page, talking a little bit about timelines for petitions. So not automatic record clearance, but when you're petitioning the court to have a record cleared, those take even longer. So Usually, generally, there aren't going to be any court hearings scheduled. They're going to be automatically granted, assuming that you make all the requirements. On the one hand, this is good because who wants to have to go to court and explain why, you've done everything you were supposed to do, and therefore the court should do what they need to do. On the other hand, it means that you sort of do all of these highly complex things, put it in the mail, send it off, and have no real way to check it, right? Like you're not going to court, you don't have a date where you can go in and make sure that everything is as it's supposed to be or anything like that. You're kind of just hanging out. Generally, petitions for misdemeanors take between 30 and 90 days, but it really, really depends on how busy the court's calendar is. And certainly, when new laws are passed that allow for more records to be cleared and things like that, court calendars are going to be very, very busy, and the delay is going to be longer. And then, obviously, if you have a really complex case, it's going to take a lot longer, and felony expungements can take months and months to complete. And on the left, I just wanted to show you the California court's official self-help guide for getting records expunged. And just to like point to the fact that this does not provide the relief people are looking for maybe when they most need it. You can see under housing and jobs, the state advice is the record clearing process can take several months. Consider record clearing as a solution to helping your next job or housing search, not your current one. So, if you're excited about something and it requires that you get your record cleared, sorry, bud, maybe next time. That's basically the official advice, which is it's just rough, right? So I think the important takeaway here is if you have clients who are eligible to have their record cleared, that is something that they should be doing sooner rather than later, right? Because it does take time. And then this slide here is just another slide that I thought was sort of telling. Again, we think that expungements and things like that are predictable and easy-ish and all the things, but the San Mateo County Law Library's research guide on expunging your record, their ending advice to people using this self-help guide to try to get their record expunged is, if you are denied, don't worry. There's no limit to the number of times you can apply for expungement. You might have just caught the wrong person on the wrong day. And I just know, like, if I was somebody who had put forth all this information about myself, made all these copies, done all of these things, if I was told, like, just try again, like, you probably just got the wrong person on the wrong day, there's no other rhyme or reason to it, that would not feel particularly good to me. So I think just thinking about this from a trauma-informed perspective, because it would seem in my research that the courts are not necessarily doing that. I want to pause there before we get more explicitly into advocating to see if anybody has any questions or comments. Gemma said, incredibly cruel system, almost banks on folks failing, especially considering the lack of robust social safety net for this population. Yeah, thank you for that comment. And I think that the important thing is just to understand how slow and technical, two words that I've used like 9 million times during this presentation, the court system can be. And I think especially when people are in crisis and when people have been traumatized by the court system, it can just be really difficult to advocate for oneself. And so our hope here today is that you all can take some of this, and go forward to help people to advocate for themselves and to help people just to make good decisions about when and how they try to get their records cleared and how they advocate if their record doesn't get cleared, right? Or is delayed for a very long time. And Sam asked if someone clears their record, could a background check see that they cleared their record? And the answer is yes. And we will get into that more on the next section. But the other thing is that clearing one's record is kind of a misnomer because there's a bunch of different ways that you can clear a record, but the bottom line is like you can't what's the cliche? Like you can't put the something once it's out there, it's out there, right? And there are some times in which you should be able to toothpaste back in the tube. Thanks, Garen. You cannot put the toothpaste back in the tube. Like once things are out there, they appear, it's very hard to get a record totally cleared. And even if you successfully get your record cleared and that's reflected, you can still, in some cases, see that there was a conviction that was expunged or sealed or something like that. Any other questions?
I just wanted to go back to the probation conditions point. Sorry, it's a little bit out of order. But one thing that I meant to mention at that point is that there are all these rules, and as housing providers and folks in the housing space, that you can play a really important role in helping people even know what those rules are, and even advocating, helping them advocate for themselves or working with them to help make those rules less onerous. For example, I have spoken to a friend who runs a housing program here, and a lot of times what she does is help clients kind of advocate to their probation officer, just saying, "Hey, actually, there's no way I can meet this and that requirement," or send a letter like that to the judge and explain, like, here are all the things I'm doing to get stable, and here's how this requirement's gonna like conflict with that. So there is that kind of like wiggle room and room for advocacy, just in case everyone was feeling incredibly depressed after looking at those list of rules. But I also wanted to say that it kind of varies by probation officer too, how much they're going to enforce them. And so that also makes it tricky because you kind of have to get to know the individual probation officer and as well as the vibe of the department, to kind of understand like how much are these really going to matter in practice? And sometimes it's a lot, and sometimes people let things slide. So those were just some thoughts I meant to share earlier about those probation conditions. But I'm going to put the full list of those rules in the chat once I stop sharing.
Thanks, Shivani.
Mhm.
Elizabeth Ramirez asked, is there a waiting period prior to applying to expunge one's record? There's generally, it's like a year. You either, if you finish probation and that all goes off without a hitch, then you can apply to expunge. And then generally there's like a 1 year waiting period after sentencing. Yeah, go ahead, Sabani.
Yeah, no, exactly. But then in some cases it can jump longer. Like I think for a felony, if you want to apply, or even for getting automatic expungement, I think it's like if you get a probation violation or a revocation of your probation, they have to wait 4 years. So it can kind of vary.
So we've been talking at you all a lot. So I think maybe we have one more section left, and maybe now would be a good time to take a little break. I don't know. I can hand it back over to you, Maddie.
Yeah, let's take a 5-minute break. I'll put a timer up on screen, and then when we get back, we will finish up this training. So Esther and Shivani, whenever you're ready.
Thanks, Maddie. Okay, so as I think Sam, right? Sam predicted where we were going on to next, which is talking a little bit about managing convictions once they've happened, whether or not you've gotten your record cleared, and also thinking just about how you all can help advocate for your clients who have criminal records, how you might be able to use criminal records in order to advocate for your clients, all of that kind of stuff. So we'll talk about managing convictions first, then we're going to talk a bit about the Fair Chance Act and how that protects people with criminal records in employment and housing. And then we're going to talk about mitigation a little bit in both the context of housing and trying to sort of mitigate the context, using mitigation evidence to explain the context in which a conviction occurred, the underlying conduct, and also using that same information to advocate to get your record cleared. So next slide. I think just something really important to understand is that convictions endure. As Garen reminded me, you cannot put the toothpaste back in the tube. Even after expungement or sealing of records or any of that, someone's conviction can still turn up on job or housing applications. And a couple of things here. One is that on really high level, high security databases, like if you're applying for a federal job and they're using the FBI database or whatever, in there they will have all information about any contact that you've ever had with law enforcement in theory, right? And then on the far other end, you have these sort of like third party profit kind of background check things that a lot of landlords and people use that pull generally from a whole bunch of different websites to put together like a conglomerate of what somebody's record looks like. And those are often super inaccurate because, as Shabani said, like once a record is cleared, the county needs to be proactive about it. So not only do you have to assume that the county is being timely and proactive in clearing the record on their database, you then also are assuming that this third party for-profit database thing is regularly updating and refining people's records based on the latest data. And that's just not really the case. So all of that is just to say it's like records are going to reveal the most when you're looking at sort of the low end where the information just might not be accurate, or the high end when you're looking at like federal government databases and things, which include everything, regardless of what you've done. Generally, you can answer no legally to any questions about convictions that you have expunged or successfully cleared. But I think it's just when you're talking with clients, it's important to note that, depending on what database they use or what they're searching for, employers and landlords may still be able to pull up someone's record and see that they were convicted and that the conviction was dismissed if they run a background check. And so, often what is maybe the better idea is to just say, yes, I have been convicted, but that's been fully expunged and, it's no longer on my record. I'm not trying to give legal advice or anything there, but I mean, just be kind of getting ahead of that. Because sometimes if you answer no, and then it does show up, that can just be a difficult thing to explain sometimes to folks. So that's just something to consider, but legally you can say no. Once you have had your record expunged, what it has the effect of doing is basically going back and dismissing the previous charge. So legally you can say no. Some jobs will reveal the conviction as part of their standard background check. So like I said, like government jobs and jobs with really, really high security clearance are going to show sometimes every single time you've had contact with police will come up, right? Like anything that's been in your rap sheet that's been reported through official law enforcement channels will show up in those. So if somebody is applying for a job that has government or high security clearance, they should disclose their expungement and explain that, because that will come up. Next slide, please. So even if you clear your record completely, it's important to note that clearing one's record does not, as we just discussed, necessarily remove the conviction from criminal history or background searches. Also, if you clear your record, it doesn't reinstate your right to possess firearms. So there's all kinds of ways in which, in California especially, your right to bear arms can be revoked for different crimes that you can be convicted of and different facts under the underlying crimes. It's something that a judge can order, and sometimes it's automatic. Even if you clear whatever charge that was and you expunge your record of that charge, you still cannot possess firearms. You have to go through a whole nother process in order to get those rights reinstated. As I said, clearing a court record does not allow you to omit the conviction from applications for government issue licenses. So this is along the same lines as sort of like that FBI or high security clearance. Anytime that you're doing stuff for the government, they're going to be using, their supercharged background checker, and they can find anything. And so, just best practice there is just disclose and explain. Court records remain public record regardless of whether or not the underlying charge or the conviction that came out of the court record is sealed or expunged. So that means that anybody from the public can still go in and look at your court record. They can get access to your court record through the court, even though technically you no longer have that conviction on your record. So they could pull, the case file, they could look at the minutes from different court hearings and that kind of thing. It doesn't prevent the conviction from being used for sentencing enhancements. This is just like something to be aware of. There are certain types of crimes that when you do it the first time, it's kind of like a slap on the wrist. You do it the second time, you're looking at more serious jail time. You do it the third time, you're in prison. I mean, it's not literally slap on the wrist to prison, but each one, it becomes a much more severe punishment. In California, there's the 3 strikes rule, right? Where if you get 3 of these serious felonies, you can get life in prison. So even if an underlying conviction is expunged, it can still be used as a prior for those kinds of cases as a sentencing enhancement. And then, you can use the conviction to impeach witness testimony if the person is appearing as a witness. They can, if there's somebody who has a government license already or a specific government permit, the conviction can be used to revoke or refuse that. And then also, the conviction can be used for removal or exclusion purposes for citizenship and naturalization services. So you can be denied entry or removed from the United States based on that underlying conviction. So this may be a level of detail that is not important for like the day-to-day work you all are doing, but I think it's just really important to understand that the big thing with clearing one's record is that it shows that you did well, right? With whatever the sentence was, you followed the rules, you did what you were supposed to do, you successfully graduated or completed probation. And you can say, I do not have any current convictions because they have been expunged. You can say you don't have any convictions in general, but it may still come up, right? And that's just something to be aware of. Any questions there? Does that all make sense to folks? Okay, well, you know what to do if you have any questions. I want to get a bit into the Fair Chance Act in two different scenarios here. The first in terms of employment, and then the second in terms of housing. So, the Fair Chance Act in California prohibits employers from asking about or considering certain things related to your criminal history when you apply for a job. They are not barred completely from asking about or considering someone's criminal history, but there are pretty like narrow little boxes in which they can do it. So first and foremost, this rule applies only to employers that have 5 or more employees. Okay, so if it's anywhere with 5 or under employees, sorry, more than 5 employees. So if it's anywhere with 5 or fewer employees, this does not apply. And then also, these rules don't apply to employers that are required to restrict employment based on criminal history or to run a background check. So any kind of like high security clearance requirement in jobs overrides the Fair Chance Act, and they can ask about criminal history and that kind of thing. But if you are working somewhere with more than 5 employees who does not have a requirement that they need to restrict employment based on criminal history, then Fair Chance Act says that employers cannot ask you about your criminal history before making a conditional job offer. So in the initial interviews, in any job application or cover letter requirements or questions or anything, they cannot have any questions specifically asking you about your criminal history. Once they make an offer to you, then they can run a criminal history check and they can ask you specifically about convictions. However, they can't ask you about, this says evictions, but it should say convictions. They can't ask you about any convictions that have been expunged, sealed, dismissed, statutorily eradicated, or for which you've received a certificate of rehabilitation or a pardon. So basically, if in that job search things show up that should have been expunged, that should have been sealed, but they still show up as a conviction, an important thing to know is that you can just say, oh, actually, that was expunged. We don't have to talk about it. You can't ask about it, you know? However, they can still ask people after that conditional job offer, they can still ask about existing convictions that have not been expunged or sealed or dismissed. Does that all make sense? Big takeaway here is just that for most jobs, they cannot ask about criminal history at the outset. They can only ask about those things after running a background check and making a conditional job offer. And then they should really give, there should be an opportunity for people to explain. Cool. Okay. Next, let's talk about the Fair Chance Act in the realm of housing. So I was actually at one of these meetings, trainings like a month or two ago, talking about Fair Housing Act and the Fair Employment and Housing Act. And this is all a little bit similar to what we talked about then. That basically, it's unlawful for a landlord or a housing provider to have just a blanket policy that prohibits people with criminal records from living or renting their units, regardless of circumstances, right? You should not have a blanket ban that says if you have a criminal record, we will not rent to you. This is not to say that landlords are disallowed from running criminal background checks. They can run criminal background checks, but the way that they can use these records is really limited by law. So first of all, a housing provider's policy or practice violates California law if it constitutes intentional discrimination based on a protected characteristic, or if it has an unjustified discriminatory effect on members of a protected class, even if that is not the intent. So this is something that we talked about last time. You cannot have something that says we will not rent to any, we will not rent to anybody who has a DUI conviction, just period. That would not be allowed under California law. But you also couldn't say, we're not going to rent to, I don't know, people who have a DUI if you know that in the county, if in the county that you live in, only, Black women are ever stopped and charged with DUIs or something, because that would have the discriminatory effect of discriminating against Black women, even if that was not the intent ostensibly out the gate. Landlords should always provide a copy of their policy on criminal records to people if people ask about them. And this policy also ideally will allow people an opportunity to present what's called mitigating information around their criminal history. So basically, what this means is that they're allowed to sort of provide additional context to the underlying crime that shows that they in some way are less culpable than maybe it would look just looking as the average person at whatever the conviction is. And then also they can provide evidence of what they've done since that conviction that shows, like, I'm not the kind of person that would do that anymore. I was 5 years ago, I'm no longer there. And here's all the evidence that I can show to show you that, I'm not doing that kind of thing anymore. Also, landlords should delay considering criminal history until after the financial and other qualifications have been verified. So similar to in the employment context, the idea here is that you're not weeding people out at the outset because of criminal involvement, right? You're making an objective choice and, based on all kinds of other indicia. And then maybe at the very end, you're looking at criminal records and you're giving people an opportunity to address questions that you have about those and to provide mitigating information. Okay, so things that landlords cannot consider under the Fair Chance Act, they can't consider any arrests that did not lead to convictions. So just because you were arrested by police, if that case was then dismissed, or if you went to trial and you were found not guilty, or all of the different ways that you can, be arrested but not ultimately be convicted of something, landlords cannot consider those, period. They also can't consider anything that indicates that somebody maybe wasn't even arrested, but that they were questioned by police, or that they were, taken into custody or apprehended by police, but not arrested, that they were detained, that they were for a moment being held to be investigated by law enforcement. None of that can be considered. And all of these are things that in different ways can end up on people's records, right? And so it's just very important to be aware of the fact that if it is not a conviction, if it's just an encounter with the police or an arrest that did not arise to a conviction, landlords cannot consider that, period. They can't consider infractions. Infractions are, generally sort of like the lowest of the different criminal, like groups of crimes and things. So infractions, misdemeanors, and felonies, they cannot consider infractions. They can't consider referral to or participation in pretrial or post-trial diversion or deferred entry of judgment unless the applicant provides them with that information as mitigation evidence. So these would be cases in which somebody was charged with a crime and then entered an agreement with the court and their attorney and the district attorney saying, okay, you do all of these things. We're going to put out sentencing you and convicting you for 6 months or whatever. You go to these classes, you keep your record clean, you check in with your, probation officer person, your diversion officer, like every week. And then after 6 months, the whole thing will just go away. If you do all of that successfully, that's more or less kind of what it is. you can't consider that, right? You can only consider that as mitigation evidence if the applicant presents it. Landlords can't, sorry. They can't consider criminal convictions that have been sealed, dismissed, expunged, or otherwise rendered legally inoperative unless provided by the applicant. So again, if a client has sealed a record and it is showing up for the landlord, the landlord should not be able to consider this, should not be considering these facts, even if it shows up in the record, but the client may need to explain that their record, that they had this conviction, but it was expunged. And then finally, anything that happened when an individual was a juvenile, anything that happened in the juvenile justice system cannot be considered by landlords. Okay. So we've talked a little bit about, next slide. We've talked a little bit about mitigation information, right? About things that landlords could consider or things that the court might consider in looking at somebody who has a conviction and thinking about why, regardless of the conviction, this person is a good tenant and should be rented to, and also things that the court might consider in deciding whether or not to seal or dismiss someone's record. So the first of these is like, does the underlying conduct, does the conviction relate to one's ability to be a good tenant? And I think that this is a really, really important one and a really ripe ground for advocacy for clients, right? You really want, I think often landlords will look at something and they'll see that somebody has a conviction for, I don't know, I keep using DUIs, but I'll use the DUI. And they're like, oh, that sounds irresponsible. I don't want somebody who's got a DUI. What does getting a DUI actually have to do with being or not being a good tenant, right? There are very few crimes and convictions that would actually tie directly into one's ability to pay rent and take good care of a unit and, be a responsible tenant. And so really there should be a strong nexus between renting to a person and the underlying conviction. Another thing to think about is how long ago did the conduct take place? If this happened 5 years ago, and the person is like, 30 years old or something, that's 5 years is a lifetime ago, right? Like, oh, sorry. So just thinking about time and how much time has elapsed. Similarly, if the person was young or if the person was a minor when the conduct occurred, we know that young people, we know that youth and things like that, like their brains are not fully formed. The decisions that they make are, as young people, may not be the decisions that they made as adults. That can be a really ripe area to provide some mitigation advocacy for your client. Was the underlying conduct related to a disability in some way? Was the underlying conduct related in some way to other things that were totally outside of their control? I don't know, being in a intimate partner kind of violent situation with somebody, or if this person was, on drugs and they've since gotten sober, or things like that, that just show that, the underlying conduct was either something that the person themselves has sort of processed and moved through, or that they had no control over what happened, right? Is there evidence of a good tenant history before and or after the conviction? Can you show, even if you can't convince the person, the landlord, that this conviction has nothing to do in general with somebody being or not being a good tenant? Can you show in this particular instance that it has nothing to do with it? Sure, they have this charge for, robbery or whatever, but at the same time, they have like spotless tenant history. Is there evidence of rehabilitation efforts? Has the person taken steps to address, factors that may have contributed to to the underlying conduct? Do they have steady employment? Do they have a strong ties to the community? Are they involved in, I don't know, community groups? Are they involved in religious groups? Do they have lots of family in the community? Do they volunteer? What do they do? Like, who are their people? And really like sussing all of that out to paint a full picture of the individual that goes beyond just their record can be a really, really useful thing to do. And I just want to pause there and see if there are any questions, or Shabani, if there's anything you want to add.
No, I think you did an awesome job.
Okay, cool. Well, we are almost done. You all are going to get out of here early. Get half an hour of your afternoon. There's a link here to file a complaint with the California Civil Rights Department. If you think, or if a client thinks that they have been wrongly disqualified because of criminal history, if they have been denied housing in a way that violates the Fair Chance Act, there is actually a very thorough and pretty accessible complaint process guideline at that link that they can go to um, to to basically say that to make the complaint, and it explains exactly how they'll be followed up and timeline and all of that kind of stuff. So I would just encourage folks to do that, to advocate for themselves if they are being wrongly disqualified because of a criminal history.
And just wanted to add there that, yeah, I think it has that information that it's not going to be, if they don't respond that quickly, might, need to wait like 6 weeks or so to possibly hear something if they're able to move forward with it. But I still think it's a good avenue while people are exploring different avenues, and they have a lot of interest in hearing from people and kind of collecting that data. So I think that's another good reason to encourage people to do it if they have the time. Great. And here's our contact info. So please feel free to email us. We know we just threw a lot of information your way, and we appreciate you hanging with us for, a lot of technical but important information. But we would love to hear from you and discuss anything, in more detail or follow up in any way. So we have both of our emails, as well as kind of the overall criminal legal system initiative email that you can also just email at any time.
Great. And before folks leave, we do have a satisfaction survey we're going to ask you to fill out. So I am putting that up on screen right now. It's a Zoom poll, so it should be easy to fill out. Just 2 questions. Overall, how satisfied were you with this training? And then do you have any suggestions for how we could improve future trainings, as an open response? So if folks could fill that out, it's very helpful for us in designing trainings that might be helpful for this community moving forward. And then once you finish the training, you are free to leave. I will stop the recording, and if people have questions they didn't want to ask in front of the whole group, but would rather just ask Esther and Shabani in a smaller group, feel free to stick on and ask those. But otherwise, thank you all so much for your time, and I hope you have a good rest of your days. Thank you.